Show. I'm Toni Collins, and I'm an attorney here in Conroe, Texas. The Legal Connection Show airs on Tuesdays between noon and 1 on FM 104.5 and FM 106.1. It's our local band. If you drive out of that hearing range, or if you miss part of the broadcast, or if you just want to go back and look up what we talk about today, you can get us on Facebook at the Legal Connection Show, or you can get us on, you can find us on YouTube by also Googling the Legal Connection Show, or you can go to irlonestar.com, and there's all the shows are listed, and you can just pick the one you want to watch, and then you can review back on what we are going to talk about today. Today, I wanted to do do an HOA primer. That's a homeowners association primer on what homeowner associations do, what their value is to you, and more importantly, if you are in a homeowners association and subject to the covenants that are a part of the homeowners association, and you receive a violation notice for something that you've done that the board of the homeowners association, which is just a nonprofit group, they're volunteers, says that you have violated. We're going to talk about what you can do if you feel like that violation is not true. If they're just harassing you, or they have no right to tell you what you can and cannot do, which happens a lot. So I'm going to tell you basically based on the law what you should first do structurally on your checklist, your bullet points, to see what you need to do before you go forward and act crazy. You want to step back and take a look at it and review it. But before we get to that, I wanted to go over bench trials versus jury trials in criminal cases. And that's because I've got a case going on right now that I've got that decision to make. So to speak, it's not really a decision in a criminal case. And so before I give you the scenario or set out what the law is on whether or not you can elect to have a bench trial, or if you waive it and all that good stuff, I'm going to lay out a scenario that I'm experiencing right now, and I'm going to ask Station Manager Dick what his opinion is on that. Okay, so here is just the base layout of this case. I have a client who has a clean record. He's 23. He has significant health issues. He's immunodeficient and has life-threatening. He has end-stage kidney failure and is on dialysis every other day. So he can't live without dialysis. Because of his immunodeficiency and having to be on dialysis every other day, and a litany of other health issues he has at this very young age, he can't be exposed to the jury panel or the jury veneer. So being around large groups of people, even before the pandemic, would have maybe killed him, and now it probably will. And we have medical records and affidavits from his experts and his actual physicians saying that much in the record in this case. And so he has 4 pending felonies against him that are pending in Harris County, not Montgomery County. None of them can be proven beyond a reasonable doubt by the state by any stretch of the imagination. They were the 4 cases were brought by his estranged wife, and they were all more, I think, she's using the justice system with her family and her parents to do a child custody case through the criminal system. In other words, she's making false allegations against her estranged husband so that he won't see his child. And so that's not what he's accused of in the felony cases. She's changed her story a number of times on all the different cases. There's still a possibility that he could be found guilty. All right, so that comes to my dilemma. I want a bench trial in this case because I believe that in the Me Too movement, even under almost any circumstance, it's difficult to go forward with a jury without them having all of the evidence. And a lot of times in these felony cases, you don't want to bring in evidence on a pending case, but it kind of slips in, and then it looks bad, and that's not the one they're being tried for. And so, if you've got the facts where you've got multiple felonies that are coming forward, and only one is being tried at the time, then you have to sort of strategically decide whether or not you want to go before the judge only. Is the judge fair? Is the judge biased? Or if you want to pick a jury. Well, in my client's case, he really can't even be around a jury, even with the best precautions. And right now, he doesn't see anybody. He's always at his house or in the hospital. So if you go to a bench trial, if only the judge decides, this is where the question comes in. The judge is not allowed to give probation if you have an aggravated felony. There's a list of them that the judge is just not allowed. You're going to have the minimum of the prison term if you're found guilty in the guilt-innocence phase. However, the prosecution can offer probation or deferred or what's called a pre-sentencing investigation. But in all of those cases, the prosecution requires that you plead guilty, and then the punishment, and there's also one that's called without an agreed rec, would be determined either by the jury or the judge. And in our case, we'd ask the judge because my client can't go before a jury. So my question is this. The judge doesn't want to give us a bench trial. I mean, the judge does want to give us a bench trial, but the prosecution will not agree to a bench trial. And the way the law works is you're not entitled to a bench trial where the judge decides unless the prosecution agrees. You automatically get a jury if both parties don't agree. So the judge left it open, and she asked the prosecution to look into, talk to their chief and the higher ups in Harris County to give him some kind of a probated sentence if he pleads guilty. So they came back and said they would not give him a probated sentence, but they would allow, if he plead guilty to 2 of the felonies, that they would allow the judge to do a pre-sentencing investigation, which is something that the prosecution has to offer. You don't just get that. And so we know that the judge will give my client probation. So the question is, would it be, if it were you, station manager Dick, if it were you, and you didn't commit the crimes you were accused of, but there was a possibility that you could go to prison for up to 80 years if they were stacked, for as little as 2, and you'd be out on parole in maybe 8 months, where the aggravated would be 50%. So 1 year, but he's got some time credit, so he'd be out in probably about 5 months. Would you plead guilty to a felony that you did not do in return for not having to go to prison? Or would you risk going to prison and are being exonerated and go to trial because you wouldn't plead guilty to something you didn't do? Which would you do?
Depends on the case, like what I'm being accused of.
Okay, so I'll just give you the case because it's public record. The ex-wife accused my client of retaliation because when they had just gotten married 2 months before. They were high school sweethearts for the 8 years before that. They got married. They didn't invite her family because they knew her family would stop it because I guess he wasn't good enough for her. And she was mad at my client, the wife, because she wanted a car and she wanted to stay home with the baby, and he wasn't making enough money. And they were really young at the time. I think they were both 20 years old when all this was going on. So when she moved out right after they got married, back to her mom's, and he wanted to see the baby, but she wouldn't let him because she was mad at him, so she was withholding the child. And when he went to talk to her about it, she wouldn't answer his phone calls. She claimed that he was saying if if you don't drop the charges against me, then I will, kill your family, is what she said. And there's no evidence that he would ever do that. So she's claiming that's the retaliation. So there's really nothing there. But then they charged him with aggravated kidnapping because they said with aggravated kidnapping you have to have an underlying felony, and so she claimed that retaliation was the underlying felony, and that when he went to go talk to her, when they went to Galveston for the weekend, which she went on her own to go, stay with the family, when they went to Galveston, that he kidnapped her, and so it made it aggravated kidnapping. She stayed the whole weekend. She didn't call anybody. There was nothing. They just went to her family and they came home. But he got indicted on those two felonies, and they got back together 2 weeks later, and then they lived together again and all that stuff. But they did all this stuff under the radar without her parents knowing, because her parents, she was holding to this felony accusation, and that's been going on for like the last 3 or 4 years. That it's kind of been on again, off again, but not with anybody really knowing. So those are the facts of the case. There's really nothing to substantiate retaliation or aggravated kidnapping, other than they don't have any proof that she wasn't kidnapped, because it's he said, she said. They didn't take any pictures that weekend, and nobody was with them. So there's nothing to prove he did, which he would win. But usually in felony court, you can't rely upon that. It's usually guilty until proven innocent, whether you like it or not. So those are the facts of the case. Knowing if you were married, and you are married, and your wife was mad at you, and then these accusations came against you, and let's say that you were you were young, you weren't well established, you didn't have much money, and so the system didn't favor you. They more favored your wife, because she had more, I guess, standing in the community. So knowing that, what would you do?
Flee the country.
Would you really?
No.
He can't. That's an option for him.
I don't. I mean, it's one of those.
I mean, it's you either lie that you did it to take the risk away, or you go to trial and run the risk of going to prison for something you didn't do, but you're also so sick if you go to prison you may die. So it may be a death sentence. So
I always fight.
See, I do too, but it's not my decision, and I have no idea what to do on this one. So that's why I kind of am throwing it out there. Even though my discussion today is going to be bench trial versus jury trial, because they're fighting me on everything. I want a bench trial, and for whatever reason, the prosecution will not agree to a bench trial. Why? Why would they not agree to a bench trial? Whether it's a lot more work to go to a jury, and if they thought he was guilty, they're going to win by the judge, but they will not agree to a bench trial under no circumstances, which to me tells me they know he's not guilty, and they know the judge is going to see that. So I don't know.
Yeah.
All right, so you don't know what you would do, or you would flee the country. Those are your two.
No, I would just fight.
You would fight?
I'd fight for it.
Okay, I would. My inclination is to fight for it, but I can't make that decision. I have to give that to my client, but my client is so young and he's sick. And so I don't know that he's in a position to make the best decisions. So I have until Friday before we have to tell the judge whether we're going to take the PSI and he'll plead guilty. And when you take a PSI, and you have to own up. You have to say, I did this. And that's another problem, because he really didn't do what he's accused of. I mean, she's not filed for divorce. They're still married. They were seeing each other for a year and a half after this. And then she got mad at him again because he didn't give her the money she wanted or something. I mean, it's just, it's just bad. She got these crimes to stick. All right. So, but that being said, not really knowing what to do, it's kind of a decision of my client. We are going to talk about initially the bench trial process versus the jury trial process in a felony trial. And then if we have time, we're going to get to the dilemma of when your HOA accuses you of a violation that is really not a violation, and what your options are to go forward, whether you want to do a declaratory judgment or work with them. There's a litany of things that are provided for in the covenants, and also with some basis in the statute that you can do. And we're going to talk about that later today. if we don't make it today, we're going to talk about that next week. And I do want to add that Station Manager Dick has told me that we will be able to go on location in the future for our show, and that I'm going to start doing a segment called What's Going On at the Courthouse. And we're going to go over, we're going to interview people outside the courthouse and ask what they're going in for and what their position is. If there's any one legal question that they'd like to ask an attorney, me, and with the disclosure that it may not help them and it's free advice, and that's exactly what they're getting. And that, and then ask them if there's anything they want to say about their case. And I think that'll be kind of fun, but that is another day. All right. What is the bench trial process? A bench trial is tried to the judge only. There's no jury. A criminal defendant can take their case to trial before a judge or a jury. That goes for civil cases too. But in civil cases, the difference is you're entitled to a jury trial, but you have to ask for it by statute in a timely manner. Usually that's 30 days before the trial is set, and you have to pay the fee. If you don't do that, you're going to get a bench trial unless both sides agree and pay the jury fee and the judge agrees to that. In a criminal case, it's very different, and I didn't know that. I do a lot of civil cases, and I've always done jury trials in criminal court. I've never not wanted to take a trial to a 12-person jury because I like the idea of, like in 12 Angry Men, of people sort of discussing it and looking at the evidence. What I have learned from jury trials, though, is that as well-meaning as they are, a lot of times they will take innuendo, or they'll take something that was presented that wasn't focused on by either the prosecution or the defense attorney, and they'll make it like a primary part of the case when usually they've read it wrong or listened to it wrong or whatever, and point and then they don't go use the standard of finding the defendant guilty beyond a reasonable doubt. They've just found him guilty by some nugget that they've found. And the example that I want to give is that we had a jury trial here in Montgomery County, and it was a DWI case, and it ended up getting dismissed by the prosecution after the judge granted us a new trial because there was lots of prosecutorial misconduct in this particular case. It was bad. And even the bailiff was basically asking the prosecution what they thought they were doing, after the jury left and before the trial was over. It was really bad, the things that they were trying to pull. And so the jury ultimately, in this case, found my client guilty of DWI, but they were, again, I'm not going to go into all the drama and the details of the things that they were doing that were inappropriate, but there was many things, and that's why we got a new trial. But the jury there wasn't any evidence in this case. It was a DWI without any blood alcohol, without a blood test, without a warrant. He passed his field sobriety test with flying colors. I mean, everything about this was a win. I wouldn't have gone to a jury trial had I not thought that we were going to win. But the jury decided that they heard in the body cam of the officer that there was a second officer that wasn't even a witness say that he believed that the HDN, which is the our N nystagmus, it's the HDN, it's the I forgot what it stands for, but it's the eye nystagmus test, and I should know that. So I've done enough of these jury trials. Anyway, the eye test, when they stop you and they ask you to do it. I'm just going to say one more time to all of my future clients: do not do your field sobriety test. If they ask you to do it, if you're stopped, if you're drunk, if you're not drunk, no matter what, do not submit to field sobriety test. Just say no, because by the time they're asking you to do that, they're not asking you to exonerate you. They're asking you so they can arrest you, and they're gathering evidence for the trial. Just don't do it. There's no legal requirement to do a field sobriety test. Just say no. My attorney has asked that I not do anything. Blame it on the attorney, even the one you don't have. Just don't do it. I'll be your throwdown radio attorney. Just say no. I'm not going to do those. And if they ask you for a blood test and it's Monday through Friday during the week, don't give consent to a blood test. Never give consent to search your car. The only thing you have to do is give them your driver's license, and if you don't have that, your ID or your name and your address. But short of that, don't do anything else. And so in this case, my client had done the field sobriety test, against my better, my suggestions to him, because he's been my client for a while. But he did very well. He wasn't drunk. He did very well, exceptionally well. And he did had the wherewithal to not do a blood test and say no to that, which was good. And so none of that came in. But in the video, the jury said they thought they heard another police officer in the background say that my client did not pass his nystagmus, his HDN eye test. And when the police officer, who's not a doctor, is looking at your eyes when you're intoxicated, apparently your pupils will dilate and they'll wiggle a little bit, and that's nystagmus. And they make you look both ways, and they do a series of tests, and you can look it up on the internet of what this actually is. But normally a doctor has to see that. And when they do the nystagmus test, even for a jury, the jury doesn't get like a little close in of your eyeball or your client's eye to see if it's wiggling. They're just having to trust the officer and what he's saying. And the officer's there to arrest you. So the officer is going to say they see nystagmus. So that to me was kind of a throwaway, and that didn't really mean much. But apparently the jury, while there was no proven nystagmus or questions about head injuries, which my client had, and various other things, they thought they heard someone in the background say that he had failed it. And so they found him guilty on that. And, that was ridiculous. And so the jury just came up with a statement which actually wasn't on the video, and they all agreed. All 6 of them agreed. You get 6-person jury and misdemeanor. That he was guilty because of this one issue, even though nothing else showed that he was intoxicated. So that taught me a lesson about juries. It's just you just don't know. Now, yes, we did get a new trial, and we got reversed, and it was bad, but that was not because the jury made a bad decision, although I believe they did. It was because the prosecution had employed misconduct. That was how we got the trial dismissed. So juries can be unpredictable. And so you really have to, in your jury veneer, you have to be really careful about the questions you ask and the people that you get. And, if you've got a really strong leader who can change the mind of everybody, the jury foreman, then you have to look at that too. And so jury veneer is very, very, very difficult and very, very important. And it's really difficult to do during COVID because, particularly in Harris County, I don't think they're doing that. I haven't done a jury trial in Montgomery County since COVID. But Harris County, you pick your juries at NRG Stadium, and everyone's got masks, and they've got these helmets on, and you can't see their reaction, and you can't hear them while they're not sitting next to each other. It's really, I think, you're automatically going into it from the losing side as a defense attorney because you can't see the demeanor of the people that are going to be on your jury. And so it goes to where I was going with this. Do I want to do a bench trial or I want to do a jury trial? All right, so a criminal defendant, like we were saying before, has a choice between a jury or a bench/judge trial. A trial before a judge is called a bench trial. Jury trials are more common and well known in the criminal justice world. And we're going to talk a little bit about that now. Now, jury trial versus bench trials. We've already given a little bit of insight about what the differences are, but this will give maybe a more structured view of it. A jury trial typically involves 12 individuals. 6 if you're in misdemeanor court, 6 if you're in a county court. County court is misdemeanor, so that's why you're only going to have 6 people that ultimately sit on your jury. Family law is district, and any felony case is district. So you're going to have 12 persons. You maybe have a veneer panel of 120. If it's a really, really important case, you may have 2 alternates if it's going to go on for a while. So the alternates will sit there until the jury, until all of the evidence is entered at the end of the guilt innocence phase. And then they're excused because they don't need them anymore at that point because they know all 12 are there to deliberate. I always wondered why they would excuse the alternate. So it seems to me that if somebody got sick during deliberation and they did alternate, but they don't. They usually release them. Okay, after hearing the evidence and legal arguments, the jury will decide whether the prosecution has approved the defendant's, has not approved, pretty much what it is though, has proved the defendant guilty or not of the charges against him. And it has to be beyond a reasonable doubt. We know, because we just talked about that, that's not always how it goes. Their decision must be unanimous. The judge does not decide issues of guilt, but rather must rule on the procedural and evidentiary issues, such as who can testify, what witnesses can testify, and what documents are physical evidence that your jury can consider. Okay, and why that's important on your decision or your attorney's dialogue to tell you whether you are give you the facts on when you should go to a bench trial or a jury trial is while the judge, even at the jury trial, has a lot of control over that case. Because if you need to get evidence in and the judge and the other side objects because it hurts them, the judge can sustain their objection and it won't come in. And the judge already knows about it because you've tried to get it in. The jury doesn't know anything about it. It may be so important for the person that's making the decision know that it could completely ruin your case. And that goes on both sides. The prosecution does the same thing. They can't get a lot of things in. The decision has to be unanimous. And I know if you watch all those crime shows, in real life, this applies too. If you've got a jury of 10 people that are not unanimous, that all want to go toward guilt, but 2 people are holding out for whatever reason. You're the lucky defense person. Your person really did murder somebody, but one juror has decided they have not met their burden and they have not met all the elements to find beyond a reasonable doubt to find your defendant guilty. Then it's a mistrial because it has to be unanimous. The problem you have, as you may have seen in a lot of these shows, and it's in real life, is that with the mistrial, the prosecution can keep bringing it back. There's no limit to that. If they think that they did something wrong and it's a mistrial, they may get different witnesses. They now know because of the mistrial what you're going to surprise produce. They're in a better position to win the second time around. It could be that your client or your family member, whoever, is not guilty and they'll be exonerated again. But not getting a unanimous verdict just sort of, it may help you, but it may just buy you time. And ultimately, what happens in a lot of these cases is it's not unanimous, and the prosecution gives you a plea deal. They're like, well, we'll offer a lower charge. We don't want to go back to trial once again. But, if you're not guilty and you learn because you get to talk to the jury after the trial, and if they have to actually talk to you, you'll at least see it on the jury verdict list when they sign off on it. You'll get to see how many people were for guilty and how many people for not guilty. And if it was in your favor and it was mostly not guilty, of course you'd want to go back to trial again, I would think. Unless you were able to really keep something out that's going to come back in again. All right, so really, really important. Jury trial, whether it's felony or criminal, the judge can keep things out. And those things that they keep out may be what your case requires to win. And it may be wrong, and it may be unjust, and you may be mad as all get out. And you've got the process of appeal because the appellate court may believe the same thing. But appeal is not as favorable as when you're going to trial because now depending on what your basis of appeal is, the grounds for the appeal, the standard for your proof is usually not in the favor of the person that's appealing. It's usually to get a case reversed on appeal is far more difficult, regardless of what the facts are, because you've already had somebody that's ruled against you. At a bench trial, the judge rules on the procedural and the evidentiary issues and takes on the jury's role as a fact finder. And that's good because the judge already has all the information, whether it was entered into evidence or not. The judge has heard you try to get it in. And you can also, in a bench trial, or in a jury trial, but I just want to emphasize in a bench trial, you can make an offer of proof, meaning the judge says, I'm not going to let that in as evidence, so the appellate court can't see it, but the appellate court still sees it if you say, this isn't for evidential purposes, this is for appellate purposes, so we can get in the record. You make the offer of proof and you argue why it should be in there, so the judge is hearing it. The jury doesn't get to hear that when you do an offer of proof, so that's why the judge is a person. They're elected officials. Most of them, a lot of them, not most of them, but a lot of them have not got that much experience. The ones that were just elected in Harris County, a lot of them were only 2 years out of law school. So these are people like you and me, well, with a law degree, that got on the bench. Now, I want to add, a caveat that if you go to a JP court, which you can do for HOA cases now, the judge doesn't even have to be a lawyer. The judge can just be a citizen that was elected to that position. So the law is kind of crazy. But I won't say that JP courts are easier. They're just going to be, I think, as strict as a judge that went to law school hearing the evidence. But with JP courts, they're not courts of record, so that if you get a bad deal in JP court, you've got to appeal it to a county court, which is a court of record, and then it's de novo and you start all over again. But JP court's a lot less expensive, and it's not as the procedures are a little bit looser, and I think it's just less stressful for everybody going to JP court. Still, judgment still sticks. It still is valid, though. Now, whether your trial, I'll finish this last part of it. The judge will make the rulings, hear the evidence, and decide whether or not the defendant is guilty or not guilty. So that the judge is the judge and jury in a bench trial. Whether your trial is a bench trial or a jury trial, the process followed during the trial should be the same. And if you are convicted, you are entitled to an appeal of your conviction in a higher court. So the same thing applies. It's just who's making the determination, 12 people or one. The court is required to follow the same rules of evidence and procedure in every trial. The judge cannot rule differently in a bench trial than in a jury trial. Because a jury is not present, a bench trial may be a bit less formal than a jury trial, but all rulings must be consistent. And again, that kind of goes toward, why would you even go to have one person? That was always my position on it. Why have one person make the decision? Why not have 12 minds make the decision? Because the judge has so much control over what's coming in that the jury will hear. And if you've got a very complex case and a defendant that you really need to testify, but you don't know if they're going to open the door to things that have not even been put on trial yet, then you might be better off with a bench trial. And there have been a lot of cases that I've been involved in where a second chair that have gone to the judge in a bench trial, and they're very serious cases, but it's because the climate in the community may be so strong against a particular issue that you could not get a fair trial in that jury, and you may have been denied your right to transfer venue, or maybe you didn't ask for it in time. So you may want to go to a bench trial for that reason. And it may just be that the judge is very fair, and why would you go to 12 people that you don't know when you have a history on the judge and they're fair? So in my particular case, I really want to go to trial to this particular judge because she's hard on the people that really are guilty, but she's very fair and she's always thinking. And I want to say probably one of the most heart-centered judges that I've seen in the criminal defense or criminal system in a while. So given that option, of course I'd want to go to a bench trial. And that's why the prosecution more than likely does not want me to have my bench trial, because I've got one fair juror. I don't have to go glean out whether they're biased or not. She's very, very fair. Okay. Does a defendant have a right to a bench trial? We've gone over that, but this is the actual text on it. No. While a constitutional right to a jury trial exists in most criminal cases, the same isn't true with a bench trial. A defendant may waive or give up the right to a jury trial, which I've already prepared all that, and my defendant waived all. He knew what the downside was to it, and he has been, I guess the judge, before a party pleads guilty on their own without a jury trial, brings them out so that she can tell them that they're losing, what the injury or the damages would be to them if they make this decision. And so basically reading them the rights, but elaborating so they can make the decision with an informed decision, so they're not just following whatever their attorney said. So you have to, in a criminal case, it's in the statute that you actually have to have it in writing before they can actually waive their trial. But if the prosecutor objects or the judge rejects the defendant's waiver, then the trial will go before a jury. So it's just the opposite in criminal cases than it is in civil cases. And in our case, the judge told us she would give us a bench trial if we proved that my client was immunodeficient and that his physicians and all the experts agreed that he was too sick to be exposed to other people that would basically be a death sentence to him. And we provided all that, 2,500 pages of medical records from the experts and his own physicians by affidavit. And then even the prosecution wanted them to come in and testify, and the judge said, no, we're not going to take our first responders out of the operating rooms to come testify to something they can put in the very same thing they're going to say in an affidavit. So the judge said, if you bring that, we'll give him a bench trial. And then when we brought those that day, she said, I don't want to make a decision on this, see which we can work something out. So we still don't have the bench trial. So the rights are this: rights to a jury trial only in serious criminal crimes. And this is like a little bit of text in this particular article, which was in the state law library. It says the U.S. Supreme Court determined that defendants have a constitutional right to a jury trial only in serious cases and those that carry the possibility of 6 months but not those that carry the possibility of 6 months or less in jail. They are not guaranteed a jury trial, which is a little bit weird. I thought you were always guaranteed a jury trial. If you are charged with the possible penalty of only 30 days in jail, you are not entitled to a jury trial. So if you go to traffic court and you demand a jury trial, you are not going to get a jury trial. If the substitute judge that comes in, and they're usually local lawyers in these small towns, Oak Ridge and Splendora, and the few, I think Patton Village, and the few small towns that I've worked in, a lot of times they have visiting judges, and the visiting judges are just people that are a member of that community's bar, and they sit and they do the ticket cases and stuff. But I've never been denied a jury trial except for this once. This is the only time. Well, I've never been denied a jury trial at all. Let me say that. In civil case, when I apply for it, and you pay the money, you get it. Criminal, you're always going to get a jury trial. Even except for with these lower level cases, and even in ticket court where you're Class C misdemeanor, you're generally not going to go to jail unless you fail to appear. Then they'll put out a warrant and you will go to jail. So that's the exception. Failure to appear is an actual misdemeanor, even because you fail to appear on your tickets, which a lot of people do, because they don't know about them or they've just disregard them, I guess. But if you ask the stand-in visiting, substitute judges in the small ticket courts, JP courts, or they're not even JP courts, the municipal courts, to give you a jury trial, they usually will, and it's usually just the people that get off the street. It's usually a hoot because I've done them, and they'll always find you guilty. You're not going to get past a jury trial on a speeding ticket and not be found guilty because everybody's sped before. But it's kind of fun to do. So if you want to just give it a shot and try your hand at being an attorney and challenging the radar, the stuff you get from Google and all that stuff, you could do it. But remember this: if you do that, you're going to have to get an expert to be. You'll have to have an expert ready, and you're going to have to ask for a reset for a trial date if you do to get an expert, because you have to give them the prosecution at least 20 days notice, I think what it is with your experts. And you'll have to get a radar expert if it's radar, something like that. So they're not just going to let you admit this evidence about radar and how it works and stuff without an expert. So it gets a little bit more serious. But if you want to try it, it'd be a fun thing to do. All right. So if the prosecutor objects I'm sorry, I've already read that part. The Supreme Court ruling, the states are free to provide greater jury trial rights to criminal defendants. So the jury trial, the states can, like I was just saying, the municipal courts can give you rights, but they don't have to. All right, deciding between a jury or a bench trial, that was our dilemma today. The decision to waive the right to a jury is a weighty one and must be made by the defendant, not the defense counsel. Because, of course, you've got to give this advice. Your defendant always has to make that decision. You can't, and my clients always do this to me. It makes me crazy. What would you do? It's not my life. I'm not risking my freedom. And I may be Racehorse Haynes or Rusty Hardin or Randy Sorrells or, one of the best attorneys in the state. But I might still lose if you get a jury that picks out something weird in a video that never even came up before. It may not have even really have been said. So defense counsel can't make the decision, but they should give you the information you need to make an informed decision, which we're trying to help you with today on the show. Okay, the advantages of a bench trial. I think we've gone over that briefly, but we're going to go over it again because I'm still having a dilemma about my own case. And I also want my client to watch this so I don't have to repeat it to his entire family. So it's going to be a twofold. My recording today will help all of my defendant's family, hopefully. You get a quicker resolution on a bench trial. Bench trial is usually quicker way to complete a case because it can be scheduled sooner and does not require jury selection or jury instructions. You don't have to do a closing argument. It doesn't have to be as elaborate. And you usually don't have to do an opening statement, but I would never disregard doing either one of those, even to a bench trial. But the jury instructions and the jury selection do take quite a while, both of which make a trial process take much longer. Now, dealing with irrelevant and damaging information. In some trials, information might come out that puts a defendant in a bad light because you're not trying to bring it up, but then this one little nugget of information comes up. It says it'll tell you the whole story, but just something that sounds bad to your defendant, and it comes out. Even if the information is technically irrelevant to the charge, and the judge instructs the jury not to consider it, the juries have a tough time setting aside that information, just like the judge has a tough time setting aside information that isn't in evidence that she already knows about. A judge might be more neutral than a jury and better able to focus on only the information relevant to the case. Say there's a good chance witnesses and other information in a case might indicate that the defendant is in a gang or has gang affiliations. And even though the alleged crime is not gang related, any connection that comes to light that raises concerns to the jury members might automatically view the defendant as a criminal and be more likely to convict him. And that applies to prior DWIs. In my case, my client pled guilty and got 2 days time served on the only thing he ever pled guilty to was an assault on this very wife that brought all these charges. And it was a mutual fight, but he pled guilty at my advice, but he took it, so I'm never going to do that again. It was his decision, but I thought it was the right decision at the time because it was a mutual fight and they were married and it wasn't going to be an issue. It was to get it behind them. He got nothing. There was no fines or anything. It was so minimal. But if that came out, this would hurt him. And of course it's going to come out, even though it shouldn't, because she's, the wife in my case is saying that he was retaliating against her for that fight they had, a year and a half before, but they had no other incidents, and so that this is why, in this case, I think the judge would be a more unbiased in the sense that if this came out, which it will, she would put that aside. Now, applying the rules. If the case turns on applying a complex legal rule to the facts of the case, some attorneys and legal experts worry that jurors could have difficulties with the process or even ignore the rule. Here, having a bench trial with a knowledgeable judge versed in the rights might be a better choice. Some experts also believe that juries tend to decide issues on emotion rather than applying the legal rules that they have been instructed to use. And that's why I want to go to a bench trial, if we have to go to a trial at all on this, because the judge is a little bit more immune to the emotional side of it. She's seen it all, or he has seen it all. That usually a lot of these judges have been on the bench for what seems to be an eternity. In federal court, they're appointed, up to 40 years ago, 50 years ago, as long as they can stay living because they're appointed for life. And they do criminal and civil, but they've seen it all. And so, but you also have to look at whether they're biased or they're hardened to it or they're too hardened to it. So they can't see the emotional side to it all. They've got to have something more than a mechanical heart for a judge. So if you have a judge that's still, sort of ruling with the facts, and using the statutes and the rules and the facts, but also can have a heart about it, then you've got a good case for a bench trial. Now, the disadvantages of a bench trial. Only one person decides, that we've discussed before. At a bench trial, the prosecution has to convince only one person of the defendant's guilt, while at a jury trial, the burden increases to convincing all 12 jurors. Put another way, the defendant may win if only one jury holds out for an acquittal, leading to a mistrial and perhaps a good plea bargaining or dismissal of the charges, which is what I was saying before. So if you can get one person to agree and you've got kind of iffy facts, then, and I think that's what happened with Ted Bundy. He would like wink and flirt with the jury, and they would exonerate him, and then he'd get out and go kill a bunch more people. So, but if one person exonerates you, you've got some leverage even after you're set for trial, and you've been to trial, because at that point, with a mistrial, you're either going back to trial, perhaps with worse evidence or better evidence, depending on what came out, plea bargaining or dismissal issues. Dismissal options, sorry, not issues. Okay, the judge knows all the evidence. This is the part I really like. At either a jury or a bench trial, the judge decides what evidence will be admitted. Prejudicial, irrelevant, or untrustworthy evidence is excluded, and ideally, the jury never hears it. But at a bench trial, where the judge is the jury, it might be hard for the judge to disregard damaging evidence that is technically inadmissible, no matter how conscientious the judge might be. That's why I went to bench trial. Also, there is this is supposed to be a disadvantage, but these still sound like advantages to me. The judge to a bench trial, the judge will follow the rules. In some cases, the defense strategy is to hope that the jury will not follow the rules and will acquit on emotional or political grounds instead. That's what the prosecution wants in our case. For an example, if the case has been overcharged, heavy charges for a minor offense, that's my case too, if even an offense, the defendant is sympathetic. The charges are unpopular, such as marijuana use or medical use, or the prosecution is heavy-handed or a bully that the jury might say no to anything that the prosecution wants because they brought a charge that was overbroad, something that didn't actually happen. This makes me want to go for a bench trial more and more the more I read this. The judge is not likely to rebel in this way. Pressure to convict. Some experts question the neutrality of judges when deciding whether a defendant is guilty. This is a con. Critics or cynics suspect that because they hold public office and may have to stand for re-election, judges may be tempted to please the public's perceived desire for a conviction. That happened to me in a case I did about 12 years ago. The jury found my client guilty with no evidence, and so the judge decided, and it's not what I wanted because this judge was up for re-election, but I had not requested that the jury decide timely. Well, I did, but then the judge overruled it, so it was a appointed appeal, which never got appealed because my client got a court appointed because I was doing this case for free, and that was just a debacle. But the judge gave him a sentence of 50 years without parole improperly. Not only did he not commit this offense, there was no evidence supporting it, but there was a political environment that was like so against him. It didn't matter what he said, he was going to be found guilty. Then all these bikers coming in with jackets and stuff that were bikers against my client. It was crazy because my clients didn't know this. It was just a political show that went awry and should have been overturned on appeal, and we still have a writ that we're going to do to get him out. But the judge handed down a 50-year sentence without parole with no evidence. And this guy had only one prior conviction, and there was no injuries or anything. And so the judge had made a political move because he was getting ready to he wanted to run for re-election on being a tough judge. And, I'm still reeling over that. I've got to get that guy out. Okay. So if you're facing criminal charges and need to decide between a bench trial or jury trial, your best option is to be represented by counsel, without question, as early as possible in the criminal process. A local attorney who has experience in court in which your case is being tried can identify the specific advantages and disadvantages to a bench trial or a jury trial in that court and give you meaningful advice about your options and represent you throughout the entire case. And that being said, I was, Dick has alerted me that I'm not even going to get to HOAs or anything like that. But I do want to add that I had a client that called me yesterday, which is kind of funny, because I did a really good job for him. I got his DWI dismissed in Harris County, and he picked up another case. And I was like, oh no, you're so young. You're like 22. How are you picking up another case? Did you not learn that? What happens is my clients are always just trying to get home. And in this case, my client was trying to avoid a fight. He was at a bar, and some people were bullying him, and I think he might have thrown a punch back. I don't know, but it wasn't an assault case. He just wanted to get out, and so he left, and he said he wasn't drunk, but he was driving fast, which is also not an indication of being intoxicated. But he was in Montana. And so I don't have a Montana license. And so I couldn't help him with there other than to say, I can perhaps guide you. But even in his case, and this goes with local jurisdictions and whether it's federal or criminal or civil, whatever the case may be, you want to find an attorney that is established in that community because they know the judges, they know the system, they know Montgomery County, Harris County, Fort Bend County, Walker County, Waller, Galveston. All of the systems are very different. They have their own esoteric little things that they do that are just different, whether it be a Zoom hearing or their procedures. And the judges also get comfortable with particular attorneys who may have been there for their campaigns, particularly in Montgomery County. They know them. And so you do want to get a winning attorney, if you can look at the record, and that has some history in that court, to give you a starting position in the race that is better than it would have been otherwise. So the last statement I made is very, very important, that you do a little research before you just kind of hire the least expensive person or your brother-in-law or something. You want to get somebody that kind of fits the criteria for your case and what you're being accused of, whether it be civil or criminal. And since I still have not got you're off the air or you have 2 minutes warning sign, I want to go over the trial process in Texas, just generally. A mistrial. If a jury cannot reach an unanimous verdict, the judge can declare a mistrial. We were watching a show last night where after 5 hours, the judge declared a mistrial. So that judge he doesn't want to go home. I mean, you don't declare a mistrial after 5 hours. A mistrial means the trial concluded without a decision of guilt or innocence. A mistrial can also occur during the trial if one side violates certain rules, which is sort of a strategy. If you don't like your jury, I've seen this, and it's really bad. It's like when football players or soccer players just out of nowhere throw themselves down on the field because they want to get more time. They need a timeout or they need, a breather or whatever. This is kind of what happens in a mistrial. A defense attorney will say something that's completely improper, but not to the extent that it would be sanctionable. So they've got a plan to get a mistrial so they can start over again. For an example, this is what's in this printout. If a defendant has a past criminal conviction, the prosecution usually cannot mention it during a trial. If the prosecution improperly brings up the criminal conviction, the door hasn't been opened by the defense, the judge will probably declare a mistrial. When a trial ends in a mistrial, the state may usually try the defendant again. However, sometimes a mistrial suggests to the state that they have a weak case and they should dismiss the charges. Sometimes you have a prosecution, though, that just wants to win, and they'll just keep bringing it back forever because they've got maybe some emotional or psychiatric problems that they need to go have some counseling on. All right, motion to suppress in Texas, really important document that I just want to briefly go over before we end today's segment. Because if you can suppress evidence and it doesn't come in, and this is usually a pretrial motion, sometimes it's during the trial, then the evidence doesn't come forward, then you can, of course, they don't have the evidence to convict you. You'll be exonerated. Before the trial, the defense attorney may file a motion to suppress. A motion to suppress is a way to keep out evidence that was obtained by police in violation of the defendant's legal rights. For an example, a defense attorney may file a motion to suppress if the police seized evidence from the accused without the proper warrant or forced a confession from the defendant without their rights being read, the Miranda rights. In a DWI prosecution, the defense may file a motion to suppress if the police did not have reasonable suspicion to pull the defendant's vehicle over for violating a traffic offense. The first thing you always do in a DWI case is you look to find out what the catalyst was for being pulled over. If it was nothing or if it was trumped up, your motion to suppress will be granted, particularly in Harris County, because I was watching these on the Zoom hearings, and the judges are granting these motions to suppresses, and these cases are being dismissed left and right. And it looked to me, even watching the video, that their field sobriety test indicated that they were probably intoxicated, but they're dismissing them on the constitutional right to that there be a reasonable suspicion. I don't know if that's constitutional or statutory, a right to be pulled over. Okay. Station Manager Dick is telling me that I must wind up now. Tune in next week because we're going to go over HOA violations and what you can do if you are falsely noticed of a violation that's either not enforceable or it's not proper. What you can do if your homeowners association goes forward and wants to fine you anyway. We're going to tell you all about what to do on that. So tune in next week, Legal Connection Show. Watch our show on Facebook, irlonestar.com, or YouTube. And remember, most importantly, to serve God by serving others. And we'll see you next week.